couple hours in customs and immigration, so of course they have to pay me.
Why do they keep you? Because of where you
Just
went?
make sure I'm not bringing guns and bombs, and because I'm actually Muslim and I own a house in Egypt, so
okay.
I'm a terrorist.
Okay. Well, I don't know any.
The proceeding begins with an appearance of order and routine, the kind of procedural calm that often masks deeper structural problems. Numbers are recited with confidence, dates are listed with practiced fluency, and the case is initially framed as a straightforward matter of non-payment. From the outset, the imbalance of power is clear. On one side is an institutional representative, armed with ledgers, notices, and formal authority. On the other is a tenant attempting to compress months of administrative confusion into brief responses, constrained by the pace and format of the hearing itself. The system moves forward regardless of whether it is fully aligned with the facts. The initial presentation of the alleged debt is treated as settled reality, rather than a hypothesis requiring verification. The figure is large, precise, and spoken as though it has already been validated. This framing is significant. In eviction proceedings, numbers are not neutral. They shape perception. A tenant described as owing a 5-figure sum is implicitly positioned as irresponsible or delinquent before any explanation is heard. The structure of the hearing reinforces this, as the burden subtly shifts to the tenant to disprove an amount that has not yet been rigorously examined. When the tenant is asked whether there are payments or credits to consider, the question is narrow and procedural. It assumes a clean accounting system where payments cleanly map to obligations. Her response immediately signals that the issue is not a simple failure to pay, but an extended breakdown in management continuity and financial tracking. Multiple managers, shifting points of contact, inaccessible accounts, and contradictory statements about subsidy payments form the backdrop. These are not excuses offered lightly. They describe a system that has failed to maintain coherent records while still asserting certainty about what is owed. The mention of government subsidy introduces a critical legal dimension that dramatically alters the nature of the case. Subsidised housing is governed by additional rules, documentation requirements, and protections. Once subsidy enters the equation, the assumption that a landlord's ledger alone is dispositive becomes untenable. Yet the response from the opposing side initially reflects uncertainty rather than clarity. There is no immediate production of documentation that clearly delineates tenant responsibility versus government contribution. This absence is telling. In a system that routinely handles subsidised tenancies, such documentation should be readily available and unambiguous. As the discussion continues, the tenant explains the variability of her portion due to income recertification. This is a routine feature of housing assistance programs, not an anomaly. Annual adjustments are expected, and both landlords and courts are presumed to understand this mechanism. However, the landlord's representatives struggle to articulate these basic distinctions consistently. Numbers change mid-explanation. Amounts are corrected, then corrected again. What was initially presented as fixed becomes fluid under scrutiny. This is where the power dynamic subtly begins to shift. The judge who initially accepted the landlord's framing starts asking foundational questions, not about late fees or notices, but about the underlying structure of the rent itself. What is the total rent? What portion is the tenant's responsibility? What portion is paid by the government? And when did those portions change? These questions expose a critical weakness. The case was brought forward without a clear, internally consistent accounting of subsidised obligations. The judge's expressed surprise that government subsidy would fail to pay is not merely anecdotal, and it reflects an institutional expectation based on experience. Subsidy programs are generally reliable precisely because they are bureaucratic and rule-bound. When a landlord asserts non-payment in such a context, it raises the possibility of administrative error rather than tenant misconduct. This moment reframes the narrative. The issue is no longer whether the tenant failed to pay, but whether the landlord correctly understood and applied the subsidy structure. As calculations are reconstructed in real time, the fragility of the original claim becomes undeniable. The total alleged arrears shrink significantly when broken down by the correct tenant portions across specific months. The recalculation reveals that the initial figure likely included amounts the tenant was never legally responsible for paying. This is not a minor discrepancy. It goes to the heart of due process. An eviction judgment based on inflated or misattributed debt constitutes a misuse of authority, even if unintentional. Throughout this process, the tenant remains in a defensive posture, responding to figures rather than driving the analysis. She mentions having documentation that could clarify the situation, but did not bring it, likely due to the assumption that the landlord's records would already reflect accurate subsidy data. This highlights another systemic issue. Tenants are often expected to anticipate and correct institutional record-keeping failures, despite having far less access to information and fewer resources to prepare. The judge's decision to vacate a prior order in a related case underscores the broader implications of the discovery. If one case was mishandled due to misunderstanding subsidy payments, others may have been as well. This is how patterns of error propagate within systems. A single incorrect assumption, once normalized, can affect multiple tenants before being challenged. The system does not self-correct until friction is introduced, often by a judge who pauses the routine flow and asks basic questions. Despite identifying significant discrepancies, the process does not halt entirely. The judgment proceeds, albeit with corrected numbers. This reflects a tension within the system between accuracy and momentum. Courts are designed to resolve cases efficiently, and even when errors are acknowledged, the machinery continues moving forward. The tenant is still faced with a substantial judgment. Timelines are imposed, and the threat of physical removal remains real. The explanation of the eviction process that follows is stark and procedural, emphasizing consequences without emotional inflection. Property will be removed and placed outside unsecured. Responsibility for loss is explicitly shifted away from the executing authority. This language reinforces the asymmetry of power. The state outlines what will happen to the tenant's belongings with clinical detachment, framing it as an inevitable outcome rather than a choice embedded within policy. The tenant's question about leaving voluntarily reveals an attempt to reclaim a small measure of agency within constrained options. She is not disputing the process at this stage. She is seeking to minimize harm. The response confirms that even voluntary compliance does not erase the judgment. This distinction is crucial. It demonstrates how legal outcomes can persist independently of physical possession, affecting credit, future housing opportunities, and long-term stability. What emerges from this sequence is not a portrait of a tenant refusing to pay rent, but of an individual navigating an opaque system where errors accumulate quietly until they surface under pressure. The landlord's inability to clearly articulate subsidy allocations, combined with management turnover, created conditions where incorrect charges could persist unchecked. The court, while ultimately correcting some of these errors, still operates within a framework that prioritizes resolution over restoration. This case illustrates how authority is often exercised through confidence rather than certainty. Initial statements carried weight because they were delivered as facts, not because they were proven. Only when challenged did their instability become apparent. For tenants without the ability or opportunity to challenge, such assertions can easily become judgments without ever being fully examined. The early phase of this proceeding demonstrates how procedural justice can falter even in the absence of overt misconduct. No one raises their voice. No one explicitly acts in bad faith. Yet the cumulative effect of assumptions, incomplete records, and institutional inertia places the tenant at risk of losing her home based on flawed accounting. This is how systemic failure often manifests, quietly, politely, and with devastating consequences. By the end of this first segment, the central tension is firmly established. The system has acknowledged its own confusion but continues forward regardless. The recalculated numbers may be more accurate, but the power imbalance remains unchanged. The tenant is still reacting rather than directing, still subject to timelines she does not control, and still bearing the consequences of errors she did not create. The groundwork is laid for understanding how such cases rarely hinge on a single decision, but on a chain of small administrative failures that compound into life-altering outcomes. As the hearing moves past the initial recalculation, the atmosphere subtly changes. What began as a seemingly routine eviction matter now carries an undercurrent of institutional uncertainty. The authority of the process remains intact, but its foundation has been visibly shaken. This is a critical inflection point. When a system recognizes error yet continues forward without fully resetting, the consequences often become more complex rather than less severe. The judge's clarification of numbers is not merely arithmetic. It is an attempt to impose order on a fragmented administrative history. Each month is treated as a discrete unit, passed according to shifting subsidy obligations. This methodical breakdown highlights how time itself becomes a factor in housing instability. For tenants in subsidized housing, obligations are not static. Income changes, certifications update, and portions adjust. When management fails to track these transitions accurately, debt can appear to grow organically, even when payments are being made in good faith. The landlord's representatives, when pressed, reveal the layered nature of their own uncertainty. Different effective dates are introduced. Portions are described as changing mid-year. The explanation is technically correct in structure, but fragmented in delivery. This fragmentation matters. In legal proceedings, clarity is power. The inability to present a coherent, uninterrupted narrative weakens institutional credibility, even if unintentionally. Yet the system does not respond by dismissing the case or pausing enforcement entirely. Instead, it adapts just enough to keep moving. The recalculated amount is accepted as the basis for judgment. This reveals a structural bias toward resolution rather than reconciliation. The goal is not to fully untangle how the error occurred or who bears responsibility for it, but to arrive at a number that can be entered into judgment and enforced. At this stage, the distinction between judgment amount and amount owed is emphasized. This distinction is legally significant, but practically opaque to most tenants. A judgment becomes a permanent legal artifact, while the actual owed balance may fluctuate based on subsequent payments or arrangements. For someone facing housing loss, this nuance offers little comfort. The weight of the judgment exists independently of immediate ability to pay, or even of physical possession of the unit. The explanation of appeal rights is delivered in a standardized manner. It assumes a level of procedural literacy that many tenants do not possess. Filing an appeal requires time, documentation, and often legal assistance. These are resources unevenly distributed. While the right exists formally, its accessibility is constrained. This gap between theoretical rights and practical ability is a recurring feature of housing court dynamics. The timeline presented is particularly stark: 1 to 2 weeks. This window is framed as generous, but in reality it compresses critical decisions into an impossibly short span. Securing alternative housing, negotiating payment arrangements, gathering documents, and potentially filing an appeal are all expected to occur within days. The system's clock does not adjust for socio-economic reality. When the mechanics of the eviction are described, the language becomes notably impersonal. Property is removed, items are placed outside, responsibility is disclaimed. This is not framed as punishment, but as procedure. Yet the impact is deeply personal. Years of accumulated belongings are reduced to objects, subject to weather, theft, and loss. The explanation strips the event of emotional context, reinforcing the idea that enforcement is neutral, even when its effects are devastating. The tenant's response remains measured. She asks clarifying questions rather than protesting the outcome. This composure is often misinterpreted within such systems as acquiescence or acceptance. In reality, it can reflect resignation. When avenues for challenge feel limited or overwhelming, compliance becomes a survival strategy rather than agreement. Her inquiry about leaving voluntarily before enforcement is particularly telling. It signals an attempt to exert control over the manner, if not the outcome, of displacement. Voluntary surrender of keys is framed as permissible, but the persistence of the judgment underscores a central contradiction. Even proactive compliance does not erase the legal and financial consequences already set in motion. This moment illustrates how housing courts often operate on parallel tracks. One track addresses possession, the other addresses debt. Even if possession is relinquished peacefully, the debt follows the tenant forward, shaping future housing prospects. Credit reports, rental applications, and background checks will all reflect the judgment. The system thus extends its reach beyond the immediate case. The judge's role throughout remains procedurally balanced but structurally constrained. Corrections are made, explanations are offered, but the broader systemic failure that led to incorrect accounting is not investigated. There is no inquiry into why management turnover resulted in inaccessible records, nor into how long incorrect charges persisted. These questions fall outside the narrow scope of the proceeding, even though they are central to understanding the harm caused. This limitation reflects a broader institutional design. Housing courts are not equipped, nor intended, to conduct audits of property management practices. They adjudicate disputes presented to them, relying heavily on the records supplied. When those records are flawed, the court's corrective capacity is reactive and limited. Errors are fixed only when they become impossible to ignore. The landlord's acknowledgement of potential late fees and ancillary charges further complicates the picture. These additional amounts, while contractually permissible, are layered onto an already confusing accounting structure. For tenants, distinguishing between base rent, subsidised portions, utilities, fees and penalties becomes nearly impossible without specialised knowledge. Complexity itself becomes a mechanism of control. Throughout this phase, the tenant's narrative about management instability recedes into the background. The system focuses on numbers rather than causation. Why payments were misapplied or unreflected is less important than establishing a figure that can be enforced. This prioritization reflects an institutional preference for closure over accountability. The power dynamics are reinforced by the physical and procedural setting. The tenant participates remotely or telephonically, limiting her ability to reference documents or respond dynamically. The landlord's representatives, by contrast, have access to ledgers and internal adjustments. Even when those records are flawed, they dominate the evidentiary landscape simply by existing. What is particularly striking is the normalization of confusion. Multiple corrections, pauses and recalculations occur without triggering concern about systemic reliability. Instead, confusion is treated as an inconvenience rather than a warning sign. The case proceeds as though the corrected numbers are inherently trustworthy, despite being derived from a process that repeatedly demonstrated inconsistency. This normalization has broader implications. If such confusion is routine, then many judgments may rest on similarly unstable foundations. Tenants without the ability to articulate discrepancies, or without judges willing to interrogate assumptions, may face outcomes based on errors that never surface. As the hearing draws closer to its conclusion, the procedural tone returns. Final confirmations are made, courtesy is exchanged. The formality of politeness contrasts sharply with the severity of the consequences outlined moments earlier. This contrast is not accidental. It allows the system to maintain an appearance of civility while administering harsh outcomes. The tenant thanks the court. This expression of gratitude, common in such settings, should not be mistaken for satisfaction. It reflects social norms and power asymmetry rather than endorsement of the result. The system rewards compliance with courtesy, even when compliance is coerced by circumstance. By the end of this segment, the case has crystallized into a familiar pattern. An initial error was acknowledged and partially corrected, but the structural conditions that produced it remain intact. The tenant exits the process facing displacement, debt and uncertainty, while the institution proceeds to the next case with minimal reflection. This part of the proceeding demonstrates how accountability often dissipates as cases move forward. Responsibility for confusion is diffuse, spread across managers, systems, and timelines. As a result, no single actor is held responsible for the cascading effects of administrative failure. The burden instead consolidates on the individual least equipped to absorb it. The narrative momentum carries forward not toward resolution, but toward enforcement. The system has spoken, adjusted itself just enough to maintain legitimacy, and moved on. What remains unresolved is not merely a balance owed, but the deeper question of how many similar cases pass through without correction, and how often tenants bear the cost of errors embedded within the very systems meant to regulate fairness. As the proceeding formally concludes, the machinery of the system disengages with practiced efficiency. Courtesies are exchanged, permissions are granted to exit the call, and the case is administratively complete. Yet completion in this context does not mean resolution in any meaningful human sense. It simply marks the point at which institutional responsibility ends and individual consequence begins. What lingers most powerfully is how narrowly the system defines its own role. The court corrects numbers, clarifies portions, and ensures that the judgment reflects accurate figures as of that moment. But it does not, and structurally cannot, address the deeper harm caused by months of miscommunication, inaccessible accounts, and managerial instability. Those factors are treated as background noise rather than central causes. The system acknowledges confusion without interrogating it. This limitation is not a failure of any single actor, but a feature of the framework itself. Housing courts are designed to adjudicate possession and debt, not to audit landlord practices or repair administrative breakdowns. As a result, systemic errors are addressed only insofar as they affect the immediate judgment. Anything beyond that scope becomes invisible, even if it is the very reason the dispute exists. The tenant leaves the process with clarity about one thing only. Time is no longer on her side. The 1 to 2 week window looms large, not as a neutral deadline, but as an accelerating force. Every day within that window carries logistical, financial, and emotional weight. Decisions must be made quickly, often without adequate information or support. The system's pace assumes a level of flexibility that many tenants simply do not have. The distinction between judgment and possession continues to shape the aftermath. Even if the tenant vacates voluntarily, the judgment persists as a legal marker. This persistence is one of the most underappreciated aspects of eviction proceedings. The loss of housing is immediate and visible, but the damage to future stability unfolds quietly over years. Rental applications, background checks, and credit evaluations will all reflect the judgment, regardless of how or when the unit was surrendered. In this way, the system extends its reach beyond the courtroom and into the tenant's future. The proceeding is finite, but its effects are not. This asymmetry mirrors the earlier power imbalance seen throughout the hearing. The institution's involvement is temporary. The individual's consequences are enduring. The landlord's role, by contrast, remains largely insulated. Even where accounting errors are identified, there is no formal mechanism within this process to address how those errors occurred or how long they persisted. There is no requirement to demonstrate corrective action beyond the immediate recalculation. The system assumes that future cases will be handled correctly without demanding evidence of reform. This assumption is particularly troubling in light of the earlier revelation that another case may have been affected by similar subsidy misunderstandings. That moment briefly exposed the possibility of a pattern rather than an isolated incident. Yet once acknowledged, it receded from view. The system adjusted the immediate outcome, but did not pause to consider broader implications. This pattern reflects how institutional accountability often operates in fragmented environments. Problems are addressed individually, case by case, without aggregation. Without aggregation, patterns remain anecdotal rather than actionable. Without actionability, systemic issues persist. The tenant's earlier description of management turnover is central here. Frequent changes in personnel disrupt continuity, obscure responsibility, and degrade record integrity. Yet such turnover is common in property management, particularly in large complexes. When systems rely heavily on individual managers rather than robust institutional memory, errors become inevitable. The cost of those errors, however, is not borne evenly. Tenants absorb the consequences through inflated balances, legal action, and housing loss. Landlords absorb little beyond administrative inconvenience. Courts absorb nothing beyond the time spent correcting numbers. This uneven distribution of harm is not accidental. It is built into how authority and responsibility are allocated. The calm tone maintained throughout the proceeding further reinforces this imbalance. There is no overt hostility, no raised voices, no explicit misconduct. Everything unfolds politely, professionally, and within procedural norms. This civility can be misleading. It creates the impression of fairness even when outcomes are shaped by structural disadvantage. The absence of overt conflict also limits opportunities for intervention. Without dramatic confrontation, there is little to trigger scrutiny or reform. The case appears ordinary, even as it reveals extraordinary levels of confusion and error. Normalization becomes a shield against accountability. The tenant's demeanor throughout remains composed, cooperative, and respectful. This composure, while admirable, does not translate into leverage. The system does not reward calm explanation with relief. It rewards documentation and procedural positioning. Without immediate access to her vouchers and records, her narrative remains secondary to the landlord's ledger, even when that ledger is demonstrably flawed. This dynamic underscores the importance of documentation as a form of power. Those who control records shape reality within legal proceedings. When records are incomplete or incorrect, those inaccuracies gain authority simply by being written. Correcting them requires effort, knowledge, and timing that tenants may not possess. The judge's intervention earlier showed that authority can at times disrupt this dynamic. By questioning assumptions and demanding clarification, the court prevented a more severe injustice. Yet even this intervention had limits. It corrected figures, but did not alter the trajectory toward displacement. Authority was exercised, but within narrow bounds. As the tenant exits the call, the system's language shifts fully into finality. Permissions are granted, farewells exchanged, and the case is closed. There is no follow-up, no monitoring of whether corrected numbers align with reality, no mechanism to ensure that future interactions between tenant and landlord reflect the clarified subsidy structure. The system trusts that clarity achieved in court will translate into practice outside it. This trust is often misplaced. Without enforcement mechanisms or oversight, corrected understandings can erode quickly once institutional attention moves elsewhere. The tenant is left to negotiate with the same management structure that struggled to maintain accurate records in the first place. The broader lesson of this case lies not in its specific outcome, but in how easily error becomes embedded within routine. Nothing about this proceeding was extraordinary. It followed familiar patterns, used standard language, and applied established procedures. Yet within that familiarity, significant inaccuracies persisted until challenged. This is how systemic issues endure. They do not announce themselves as crises. They blend into everyday operations, affecting individuals one by one. Each case appears isolated, manageable, and resolved. Collectively, they form a pattern of harm that remains largely invisible. The tenant's experience illustrates how housing insecurity is often produced not by a single catastrophic failure, but by the accumulation of small administrative missteps. A misapplied subsidy here, an inaccessible account there, a manager who leaves before resolving an issue. Each alone seems minor. Together they create conditions ripe for eviction. The legal process intervenes only at the final stage, when options are limited and stakes are high. By that point, corrective action can mitigate damage, but rarely undo it entirely. The system is reactive rather than preventative, addressing symptoms rather than causes. As enforcement looms, the tenant must navigate the aftermath largely alone. Whether she leaves voluntarily or waits for execution, the outcome is displacement. The difference lies only in degree of control over timing and manner. The judgment remains, the debt persists, and the future is shaped by a record she struggled to influence. The case ends as it began, with formality and order. Yet beneath that order lies a disquieting truth. The system functioned as designed, and that design allowed months of confusion to culminate in a legally sanctioned loss of housing. No rules were broken, no lines were crossed, and still the outcome carries profound human cost. This is the quiet nature of institutional power. It does not need force or malice to be effective. It operates through procedures, deadlines, and documentation. It corrects itself just enough to appear fair, while leaving underlying imbalances intact. By the time the call disconnects, the system has moved on. The next case waits. The next set of numbers will be read. Somewhere else, another tenant will attempt to compress a complicated reality into brief answers, hoping that clarity arrives before consequence.